Beyond Law CLC and Maharashtra National Law University, Mumbai. We are pleased to announce that we have become a knowledge partner in this platform of the Uncoding of the Gender Justice. This is a series, and the first series we thought that once we are talking of gender justice, so first we should understand what do we mean by gender justice and its awareness. And when that issue came up in the mind, we requested all the speakers who are known pan-India as well as the world across the knowledge in this regard. And there couldn't be a better moment to join with a university of such a prestige that is shortly known as MNLU. And we are glad that the Vice Chancellor, sir, Professor Dilip Ukey, has accepted this thing. Amongst us, the four keynote speakers are, three have already joined us on different topics on the platform of Beyond Law CLC. We have amongst us former Chief Justice of Bombay High Court, Justice Mohit S. Shah, a former judge of Bombay High Court, and he had also been the Chief Justice of Calcutta and a judge of Gujarat High Court. His session, wherein he had given the insights, has been very well received, not only when he gave the talk during this and even thereafter on the YouTube. Amongst us, we have Justice Roshan Dalvi, who again has already been on our platform once when we were with the knowledge partners with Symbiosis Law School, Pune, which is again a prestigious institution. And then she came and delivered on the case management, which gave a different perspectives. We have Justice Shalini from Joshi, who again came on the platform when we were knowledge partners with Symbiosis Law School, Pune. And her independent session on maintenance is again well received, not only during that the course when she was giving her insights and even thereafter. And we have Professor Dilip Ukey, who is the Vice Chancellor of Maharashtra National Law University, Bombay. He needs, as such, also again no introduction, though he's joining us for the first time on our platform. So much so, he has been awarded as the best law teacher by the Indian National Bar Association recently. And he was also the Vice Chancellor of the Nanded University, Maharashtra. It shows that the passion of study is very close to his heart. And he's also an erudite speaker, not only on Constitution of India, and his work being appreciated by none other than Justice Krishna Iyer, speaks volume not only of his knowledge, but also of the teaching skills. All these four speakers have so much immense knowledge and the way they present the things. If we start speaking about themselves, I think the entire session could be dedicated to them. But as they say, brevity is the soul of the conversation, especially when we have amongst us people who have themselves immense knowledge and people are willing to listen. So the knowledge of law, as a lawyer one says, one shouldn't speak much and let the speakers talk on their own, because we all know that people on the platform, not only here, but on the Facebook, are willing to know to the speakers and the knowledge on the, when we are speaking of gender sensitization, which is the call of the day. First, before asking Honorable Mr. Justice Mohit S. Shah to formally take over, I will ask Mr. Professor Dilip to just introduce the gender series which we intend to speak of, and thereafter we will ask Justice Shah to speak. Over to you, Professor Dilip Ukey, to start the series on the gender law series. Right, sir.
Thank you, Adakut Pikashji. Honorable Justice Mohit Ji Shah, former Chief Justice Bombay High Court. Honorable Justice Ms. Roshan Dalvi.
He's logging in. as we all often say that during these testing times, once we are going on the virtual platform, it has its own challenges. Kindly bear with us. He will be back with his knowledge to be imbibed. Amongst also, we have Mr. Assistant Professor from MNLU, Mr. Chirag Balyan. So, since the Professor Dilip Ukey comes, what are we basically intending on this session of the series? Could you just give a bird eye view till he comes across? Because I was saying there was already a problem with the low bandwidth, but definitely he would be joining us. Over to you, Justice Mohit Shah.
Yes. Good evening, my esteemed colleague Justice Roshan Dalvi, and Dr. Justice Shalini Joshi, Professor Dr. Dilip Ukey, Vikas and his team at Beyond Law, dear judges, advocates and friends. It's a pleasure being here at this webinar with this esteemed panelists, Dr. Justice Roshan Dalvi and Dr. Justice Joshi. They are both known as eminent judges and especially very good at espousing the cause of gender justice. Both of them were recognized as experts on the subject. That is why before their elevation to the High Court also, they were deputed to England for training in gender justice. That was, I think, long back, about 20 years back. Thereafter, they have not looked back. They have always been invited as distinguished guests and eminent speakers at many seminars and conferences, and now, of course, webinars. I'm also very happy that the Maharashtra National Law University has also joined this as host for this webinar and many others to follow. This series of webinars is on uncoding gender justice. Now, we all know that in our patriarchal society, women always have been at a disadvantage. So much so that even their birth is not encouraged. The last figures to come, they were just there in the newspaper day before yesterday only, in Times of India. I read that the sex ratio, childbirth ratio, that is between the age group of birth to 6 years, has been less than 100. I mean, for every 1,000 boys, the number of girls is less than 900. In fact, it is not only in rural areas that this is happening. Even in progressive states like Delhi, Gujarat, Haryana also, the ratio of girls is below 900 as compared to 1,000 boys. This may be for various reasons, but the fact that it continues now also is a little disturbing. Maybe earlier people thought that boys would go out and earn bread for the family, whereas the women would be doing only the household work. That's why there was reluctance to give them equal status. But now, even when women are earning, women are going out for work, they are studying. In fact, you must have noticed that in most of the board exams, it is the girls who are toppers rather than the boys. But still, the attitude which continues requires some elaborate discussions. And that is why this webinar has been organized. Gender justice is a very wide topic, and therefore it cannot be covered in one webinar of 1.5 hours. Gender awareness is the general topic. Child custody, domestic violence, crimes against women, personal and property laws relating to women, family law mediation, and there are various other facets of gender justice which could be discussed. It is not possible for us to cover all the topics comprehensively, but the speakers would try to touch upon some of the issues. For instance, I am going to touch briefly on this general awareness aspect, and the career problems of women. I'll be briefly touching upon them. Then my co-panelists would also be giving their views on the various other facets of gender justice. So let me just begin with this, that as I said earlier, the stereotypes were that the men would go out and earn bread for the family. That's why the boys were given asked to play with cars and other things, whereas the daughters were asked to play with dolls because they were supposed to stay back home. Whatever we may say against coronavirus, but we must give it some credit that during these lockdown periods, men have also started helping women in the domestic work and the daily chorus, home chorus. So that is one positive aspect of the lockdowns. But friends, we also should recognize that what is the extent to which women are being kept in the background as far as economy and employment is concerned. According to a United Nations report, women constitute half of the world population, almost half of the population, work nearly 2/3 of the work hours, receive 1/10 of the world income, but own only 1% of the world's property. So this is the extent to which not proper recognition is being given to women. And that is why it was stated in the Convention for Elimination of Discrimination Against Women in Article 5 that the state parties shall take all appropriate measures to modify the social and cultural pattern of conduct of men and women with a view to achieving the elimination of prejudices or customary and all other practices which are based on the idea of inferiority or superiority of either of the sexes or on stereotyped roles for women and men. Now, what is important to note is that it is not only the social and cultural pattern and conduct of men only which is required to be changed. Even that of women also needs reconsideration. And let me give you just a very small example. Ms. Indira Nooyi, the president of Pepsi company, when she was appointed, it was decided that she'll be promoted as the president of the Pepsi company. She went home. Like always, she used to go late because of the long working hours. So when she reached home at 10 o'clock in the night, she was so excited to break this news. And when she was about to tell her mother that, look, I've been promoted, mother stopped her and said, before anything else, you must get the milk for the house. So she said, but what is this? Let me tell you something important. So the mother said, no, everything can wait. First, you go and get some milk. Then Indra Nooyi went back to the market and came with a can of milk. And then she said, look, I've been promoted as president of the Pepsi company. And that is why I was so excited to tell you. Why did you stop me? Couldn't you have told him? Indra Nooyi's husband was also back home before her. So she said, couldn't you have told him to get the milk? So Indra Nooyi's mother said, no, but he came back at 8 o'clock and he was so tired. So Indra Nooyi, who went back home, reached home at 10 o'clock. She was told to get the milk and not the son-in-law who had reached home earlier, but was supposed to be tired at 8 o'clock. So that is why both men and women, they will have to change their mindset for seeing that women get equality. Now, friends, this let us examine this in the legal field. The first woman lawyer was enrolled in USA in the year 1869. But in the year 1873, 4 years even thereafter, the US Supreme Court denied admission to Ms. Bradwell. Thereafter, even in the year 1909, the House of Lords expressly held that a woman did not fall within the meaning of the term person, and therefore she could not be enrolled as a lawyer. Even thereafter, in Calcutta and Patna High Courts also, they gave the rulings in the year 1917 and 1922 that the word person may include members of both sexes. They said they cannot be enrolled. So the Privy Council had to intervene in the year 1929 and laid down the law in these terms. The word person may include members of both sexes. And to those who ask why the word person should include females, the obvious answer is why not? So that is the logic that has to be applied, that why not? The prima facie, all human beings should be considered as equal. Therefore, women should automatically be considered as equal, and that should not require any separate or independent justification. Now, in India also, the first woman lawyer to be enrolled was in the year 1921 in Allahabad High Court. She was Ms. Cornelia Sorabji. Then in the year 1923, a practicing woman, the first practicing woman lawyer was Ms. Mithan Tata. She became a lawyer in the Bombay High Court. Now, friends, what is important is that it is not only before pre-independence that this issue was there. Even after independence, there are several areas for employment for women where women were being employed and recruited on a large scale, but still the discrimination continued. That is why it was in the year 1979 when the Supreme Court had to intervene and strike down a rule in Indian Foreign Service which required an unmarried woman employee to seek permission from the government before marriage and provided that she may be made to resign if it was felt that her family life affects her efficiency. So this was in government service, Indian Foreign Service, at such a high pedestal. Even there the rules were so discriminatory. You are all familiar with the famous case of Nargis Mirza, where the Supreme Court struck down the rule, which, in case of air hostesses, it provided that the air hostess will lose job if she becomes pregnant, and then she cannot continue in service. So this was obviously declared as unethical, unreasonable, arbitrary, and unconstitutional. Very recently, you must have read in the newspapers that the Supreme Court has declared that the earlier practice of the Indian armed forces not to give permanent commission to women officers was unconstitutional, and therefore now they have been granted permanent commission. So friends, it has been rightly said that laws and institutions like clocks must occasionally be cleaned, wound up, and set to through time. And that is the need of the hour. Now, friends, we have realized this in judiciary also. There were some difficulties. We used to get women judges, but some of them would come forward and say that they would like to resign because women judges, all judges, newly recruited judges, after the recruitment are required to give 1 year's training. And 1 year's training means for first 4 to 6 months, they would be at the judicial academy in the state. Then they would go back to the field for 2 months. Another 4 months, they would come back to the judicial academy. Then another 2 months, they would go back. So for 2 stretches of 4 months each, they were required, they are all men as well as women are required to stay at the judicial academy and in the campus. Dr. Shalini Joshi can tell you more about them because she was joint director of the Maharashtra Judicial Academy for a number of years, and she has rendered yeoman services at the Judicial Academy. Now, the problem was that many magistrates, those who join as magistrates generally are there in their 20s, late 20s or early 30s. So many women judges said that they cannot continue because they have very young children, son or daughter aged, 6 months or 1 year. It was difficult for them to continue the training because they could not stay away from their family for such long periods. So we found out a solution for them. Our hostels at the Judicial Academy in Maharashtra, in Thane district, they were double-seater rooms. So we said, please bring your mother or mother-in-law to stay and the children with you so that you take training during daytime when your mother or mother-in-law will look after the children, and in the evenings and thereafter, after the training, you can look after your children. So that is how the women judges who were selected for training and employment, they continued in service. And that is the result why in Maharashtra, at the level of magistrate, which is the first entry level post in the judiciary, about 50% judges are women judges. In Goa also, more than 50% judges are women judges. They, as you all know, Goa and Maharashtra, they are both together as far as the High Court administration is concerned, and the High Court of Bombay looks after both the states. Even in the High Court office in Mumbai, we have 2,000 staff members, out of whom about 700 to 800 are ladies, women staff members. So that makes it almost 40%. We have then taken care to see that for conducting cases against women, because you know what happens that when a woman is the victim and she has to give evidence as a witness, the presence of male, lot of men in the courtroom and surroundings makes it difficult for them to depose without fear and frankly. So we issued a circular on 8th March 2013, which was International Women's Day, that all cases of crimes against women in states of Maharashtra and Goa would be tried by women judges, and even the staff members in the courtrooms would be women. So we have taken care to see that the women feel comfortable not only as judges and lawyers, but also as victims and witnesses and staff members. So these are a few steps which we have taken in Maharashtra and Goa to see that women do not suffer from any discrimination. And I think now my co-panelists would tell you more about the other facets of gender justice. So over to you, Vikas. Now, Roshan Dalvi will be speaking.
So we have the Vice Chancellor. He wanted, because in somehow
yes,
he,
so he has been able to join. I couldn't see.
Yes, he's been able to join. These are the challenges, the difference between a normal seminar, live seminar, and the virtual webinar.
Yes.
But this is the way. That's why we say this is new is the normal. Yes, sir. Over to you.
Yeah. Oh, thank you. Sorry for a disruption. It is a technological hitch. As I was about to start, in between that interruption had come. All distinguished panelists and participants. I would be brief because I missed out some part covered by Justice Mohit Shahji, and other panelists are there to speak about this in more detail. I think I am the one who is odd man out of this panel. All the judicial members who are there. I would look at it from a little philosophical point of view or jurisprudential point of view. When you talk about gender justice, primarily it is the movement of feminism which was evolved in 1960s, 70s in the United States. Then women and economics, women and sociology, how sociology deals with women and their issues, how economic deals with women issues, political science, philosophy, so on and so forth. However, it was only in the 1980s when Catherine MacKinnon, the noted feminist jurist, who has published her paper in Harvard Law Review towards feminism, that gave rise to the feminist notion of feminist jurisprudence as an independent school, different school of study as such, as one branch of study, wherein Catherine MacKinnon, then Susan Miller, Ukey Miller, they were the one who have pioneered the feminist movement in United States. And Susan Miller Ukey, rather, she had said that feminism or feminist jurisprudence is like a house having so many rooms, in a sense that there are several aspects, there are several facets which are associated with feminism, which are associated with feminist jurisprudence, which otherwise is a facet and foundation of notion of gender justice as such. Rather, when we talk about the gender justice, it is essentially one has to rely upon and refer to the notion of or concept of or theory of, as we say, feminist jurisprudence. Catherine MacKinnon, the pioneer rather, whose name the theory is much of publicized and known to. She has defined feminist jurisprudence as a range of committed inquiries into the subordinate or secondary position of women and the measures to ameliorate their conditions, rather the secondary or subordinate conditions. Feminists perceive society as a patriarchal one, legal system as a patriarchal one, laws in the legal system as patriarchal one. Whether it is a bias, because I was just watching some of the messages which are being sent by the participants, that there is a bias towards men, like might be. But primarily, the feminist theory and feminism and feminist jurisprudence, which was evolved and developed on the basis of this precept that the society is patriarchal one, the legal system is patriarchal one, laws in the legal system are patriarchal one. In that sense, that what are those measures? Because the woman, right from the early ages, which have had occupied the secondary position or subordinate positions, a dominant role by the men, either in the society or in politics or in family or in legal system. And of course, to this, there is no such a denial of the fact as such. In view of this, there were different versions which have come out of feminism and feminist jurisprudence, which I do not wish to go into all the details, like liberal one, radical one, or the cultural one, and lastly, that is fourth one, it is post-modern one. As when we talk about the notion of gender justice as well as feminist jurisprudence, primarily it is a gender equality. And they viewed, feminist jurists have viewed equality in somewhat different facets. So like even under our own Indian constitution, we look at the preamble of the constitution, primarily we refer to and rely upon justice, liberty and equality. Whether that notion of equality ingrained in the preamble of the constitution also constitutes the notion of gender equality, that is one. The notion of justice, social, economic, political, also includes the notion of gender justice. And dear colleagues and friends, wherein there is a notion of fraternity assuring the dignity of all individuals, whether that dignity also includes the dignity of women, which is to be promoted, which is to be protected as such. In view of this, not only the preamble, then the material provisions like Article 14, Article 15.3, which enables the state to enact laws, particularly for women and children. We know Article 21 and other provisions of Part 4 as well as Part 4A, wherein the duties, which are also fundamental, which are there. In view of this, the laws which have been made came to be enacted, like Dowry Prohibition Act, like the Domestic Violence Act. But as I said that I'll be brief, I will refer to few decisions of the Supreme Court, right from the Shah landmark decision delivered by the Supreme Court by Justice Y.V. Chandrachud, Senior Chandrachud. That since then, and particularly in 1997, when Vishaka judgment was delivered, Vishaka versus State of Rajasthan, as all of us know well, wherein the Indian Supreme Court, I could hear a bit about Justice Mohit Shah's presentation, wherein he has referred to it. That wherein the Indian Supreme Court first time delivered the judgment in a way invoking the international document like in the form of CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, wherein even in the absence of, because we follow dualism, even in the absence of having a municipal legislation, that international law, international legislation, international convention was invoked by the Indian Supreme Court. Article 142 was invoked by the Supreme Court in Vishaka to do the complete justice in a matter pending before it, wherein those guidelines which were laid down by the Apex Court The court itself has declared that those guidelines are the laws. They are binding upon all. That was the kind of a unique, novel way adopted by the Apex Court then in Vishaka. Till the time the Parliament enacts the suitable legislation with that effect, the prevention of sexual harassment at workplace. Freedom of sexual harassment was read into Article 21. Prevention of sexual harassment was read under Article 21, right to life at workplace. There are several such technicalities, issues which were associated with Vishaka. I do not wish to go in all those technicalities at this juncture. That workplace, whether it is the public place or even a private place, whether the notion of fundamental right has undergone a change by virtue of these decisions, so on and so forth. And initially, which I referred that without having municipal legislation, the court has invoked the CEDAW, Convention on Elimination of All Forms of Discrimination Against Women. Nevertheless, as those guidelines laid down by the Supreme Court therein in Vishaka, they were declared as law within the meaning of Article 141. Otherwise, also any such decision delivered by the Supreme Court is the law within the meaning of Article 141. However, Supreme Court took 16 years. The legislature Parliament took 16 years to enact the law with that particular effect. I think Act came into be enacted only in the year 2013, Prevention of Sexual Harassment Act at work. It shows the kind of mindsets, howsoever the messages, howsoever the mental status of men, that's what rather the precept of the feminist jurisprudence, that society is patriarchal one, legal system is patriarchal one, laws are patriarchal one. Maybe we do not know what about the judiciary. In that sense, the notion of gender justice hinges upon the notion of gender equality. Someone might argue that even gender neutrality, whether neutrality and equality, are they the same conceptually, philosophically, jurisprudentially, legally? Definitely, we need to ponder upon this. We need to address this particular issue. So, Vishaka has addressed, and then the act has come. Domestic Violence Act had come. The Roshan, Dalvi madam and Joshi Pansarkal madam, they might dwell upon this in more detail, because they have worked and they have served the judiciary, higher judiciary in the state, and handled those cases. Dealt with this, that either the recent judgments about polygamy or the judgments about the section 377, as it was there in one of the message, that is it so that we need gender justice, or do we need gender equality, or do we need gender neutrality, or whether all these three concepts or three notions are entirely different, separate, independent from each other? These are the things which are such. With this, I congratulate the organizers and thank for being partner with Maharashtra National Law University, Mumbai. Thank you so much.
Thank you, sir. It's not, we would say, congratulating me, that is Beyond Law CLC would not be suffice. Since we are the knowledge partners, if at all, it is a common platform, common knowledge sharing. And before we ask Justice Roshan Dalvi, because I've been seeing that on the right side of the chat box, there are a lot of that wherein the messages are to the effect that let's assume where the woman lodges an FIR, which is ultimately turns out to be a false one, and the persons have suffered on account of that. What suggestions, because this invariably, whenever we are talking of gender law, etc., such type of messages would be there. So we would request all the four panelists to give their intakes. What are the suggestions in this case, and how now the time has come when we also should look into the view where the men have also suffered, because some studies have of late shown that yes, it's not that the woman is always on the receiving end. Sometimes, like we did one of the webinars with Nalini Deshmukh and Dr. Anjali, at that point of time, it came into being that the anger management from both sides has to be seen. So we'd also like that there are certain suggestions as to how it can be and where, especially when we find that the cases which have been lodged ultimately turn out to be false. What is the way ahead? Over to you, Justice Roshan Dalvi. We are enamored that you have joined us.
Good evening, friends. May I?
Yes, ma'am.
Good evening. Yes, good evening. Now, I will begin with the last thing first. I thought this is a series, and today is the gender awareness series. Once we are completely aware of what gender is, and not only men and women and fighting, and we understand that concept, then we would be coming to domestic violence. Domestic violence by men, domestic violence by women, if at all. Now, so far there is, yes, no law for men, and nobody prevents anybody in the country, a democracy like India, to make a law. You can always move the parliament, and if there is enough lobbying and enough cases, parliament will certainly make the law for men. It is completely true that several women have abused the law. This law is a welfare legislation. But it is not only that this kind of welfare legislation is abused by women. All welfare legislations in India have been reported to be abused. Consider SC/ST cases. Consider even cases which are completely secular. Like, for example, I was the investor court, and it dealt with small investors. I found so many people abusing that. A civil suit was filed as a criminal complaint, for example. So, because there are some cases which are false is not the reason not to have a law. But you will realize that so many judgments of so many judges would go against women when they find that a woman is on the wrong side of the law. I have myself passed several such judgments, and I was never known to be a pro-woman judge or any such thing. But yes, considering gender, having gender a kind of a equal balancing power, that is important. And I will begin with one story first. Please listen to the story like a little child and answer me. And just as you are going on posting so many things, I would like answers to this story being posted in one word by so many of you. Okay? So we begin. There was a king. He was a wise and just ruler. He wanted to find out what his subjects lacked and what they wanted. So he used to go incognito in his land. And he found out somehow that women do not have everything that they want. So he wanted to find out what is it that they want. He asked all his ministers and nobody could answer. Then somebody told the king that there is a witch who lives at the end of the kingdom and she has an answer to all such questions. So the king said, let's go to the witch. And the witch said, yes, I know the answer, but to give you this answer on one condition, that your prime minister will marry me. So now the king was aghast and he said, no, I can't give away my favorite minister to the witch. But the witch was adamant and the minister said, I will marry her. He married her. She was dirty, abusive, etc. But at the end of the day, when he goes home, he finds a lovely woman in his home. So he says, who are you? She says, I'm your wife. You married me. I just came up. So he says, but I married the witch. But he says, I don't see that you are the witch. And the witch says, yes, you are a good man. So you are seeing what I really am. And the man begins to get his answer for the king. So now the witch gives him a choice. The witch says, I will be a witch for half the time and I will be a beautiful woman for another half the time. You choose the time. If you want to flaunt me to your people, I will be a witch at home. And if you want to love me at home, I may be a witch outside. And the man got his answer for the king. Now, what was this answer? If you have been listening to me instead of writing your posts, then maybe you'll be able to answer. Can you tell me in one word what could be the answer? There can be answers to fake stories. We tell fake stories to children. Okay, since nobody knows the answer, I will tell you that it could be many answers like equality, independence, love, sharing, caring. But the utmost answer is appreciation. How many people appreciate what a woman can do? And once this is appreciated, how many men know what all women can do for their men? It may be their grandfather, father, uncle, husband, son, whoever. Because this is a family. And a woman always considers the family as a whole to begin with. The question that we must therefore ask ourselves is that when people come to court, what do they lack? Why are they coming? What is wrong in their system? And I will show you the presentation, giving you some kind of joke, some kind of quotations, and some kind of serious thought as to why this would be. Because that is very important first to understand for gender awareness. So if you can give me a minute, I will just start my presentation. And because if I can't, I would request you to do it.
I'm just allowing it.
Pardon?
Ma'am, and you stop the annotation part.
The presentation part.
No, annotations. Once you do the screen sharing, stop that annotation.
Yes, okay. But I can't get the screen sharing now.
We are just giving.
Yes.
We have given it. Just try. Is it done or should I ask Devika?
Yeah, please ask Devika in that case.
Devika, just start doing the screen sharing. I will just check it.
Yes.
Sir, please give me a minute. I'll just.
Yeah. And Devika also stop the annotation part.
Right, sir, I'll do that.
Yes.
Ma'am, that now that power is with Devika, she will continue to do that.
Okay, so go to number 4. Yes. Now let us see what is the making of a woman. It is the joy of a daughter, a passion of a lover, the dedication of a wife, the sacrifice of a mother, the care of a sister, and the blessings of a grandmother. If all goes well, these are the various roles of a woman. Can we go to the next one, please? Oh, God. I've left the thing in this chat.
It's a marriage. A happy marriage is the union of two
presentation again.
A happy marriage is the union of two forgivers.
Completely gone. I don't know. Chat available. Will I be able to do it myself? So now, please listen to the look at this quote. A happy marriage is a union of two forgivers. There are millions and millions of happy marriages in India, but with their ups and downs, their crosses and crowns. It is because both of them try to forgive one another, and which is what we do every day in our lives, even in our office work. But why would there be a breakdown of marriage? There are various reasons. Some of them are urbanization, industrialization, now globalization, computerization, the real world, and all of those other things which you said. So there are several personality disorders. There are certain odd and eccentric couples. They're very paranoid, they're very possessive, and they feel that everything goes wrong with them. There are some dramatic people who want to show that little thing is a big thing. There are some fearful people who become withdrawn. The counselors are therefore required for them. Now in India, we had a joint family, then we have a nuclear family. Now we have a corporate mom and a surrogate mom. And how are these parties going to fit into our family life to get and mold their family? If you ask a counselor, what they say is, what is this perception in a healthy family? That there is non-judgmental attitude. We have non-judgmental attitude to our parents generally. Why not to our spouses? Then objectivity. We try to understand, well, something is wrong, but where something is right with him or her. Then communication is very important, because most marriages break down when there is no communication or not enough or good communication. So it is good to go to a counselor and find out the ways of communicating, and realistic thinking and rational behavior. That, of course, is a burden for both, all of these. Terrible. Next. So we must find out why dysfunctional family continues. They don't talk about their problems. They don't express their feelings openly and honestly. They communicate indirectly but not directly. And they don't challenge the parents' beliefs on family rules. When the society thinks goes ahead, they want to go ahead, but they cannot. So we must understand the attributes of a broken home. Sorry, I'm going very quickly because I have very little time. And these are some of the attributes, but there are many other attributes. The main being anger, which is next to danger. Only the extra becomes danger. Anxiety, confusion, depression, frustration, insecurity. And two important ones, child problems and violence. Once a violent man, they say always a violent man. Therefore, that cannot be molded. But when there is just confusion and depression, those are the cases which can be molded into happy marriages. But if you cannot mold, then what is the real principle? Better to come from a broken home than to live in one. And therefore we tell them, please understand and amicably part, so that both of you then can start your own lives separately. If you cannot do it together, there is nothing wrong about it. Instead of bickering, instead of vengeance, you part as friends. Now this is a little joke. God thought he couldn't be everywhere, so he made a mother. That's what everybody knows. But the joke is that then the devil thought that he also cannot be everywhere, so he made a mother-in-law. And incidentally, it is the same woman. So therefore, we have something like these words which can be jumbled up. Something which is untied can be united. Something which is united becomes untied, just when you jumble up the letters. Now, this is an interesting thing. There is one sentence. Woman without her man is nothing. Now, if I ask you to punctuate, you can do it in two ways. I won't waste time asking you now. Woman, comma, without her man, comma, is nothing. And woman, comma, without her, comma, man is nothing. So if we appreciate this and go on together as partners for life, we are going to be man and woman together who can do nothing without one another. And now what the woman does? God says, oh, one man shouted, God, why did you create a woman, just as so many of you are shouting just now? And God said, to do the work of two men. And you will know how many women can multitask. If you are sitting down today without any stress and writing out all your chats, it is because some woman in your house has done what otherwise you would have had to do. And we women do that work and come and speak to you. So therefore, Rabindranath Tagore, on a very serious note, what did he have to say? Oh Lord, why can't a woman take charge of her destiny as we have taken by now? Why does she have to wait alone by the roadside, head bent, eyes forlorn, waiting for a miracle in the morrow? Today, tomorrow has come, and that miracle should have become reality and is beginning to become a reality. It is time that we both go together as partners in progress. And therefore, a successful woman, who is she? A successful woman is the one who can lay a firm foundation with the bricks others have thrown at her. And the bricks that you have thrown at two of the male judges who have spoken and who have been gender just always is the foundation of my presentation. So, now when we see husband and wife together, what are they? They are two sides of the same coin. They can't face each other, but they stay together. And there are millions who are staying together happily as well as unhappily. And this anger is what I told you, just one letter short of danger for both men and women. And this is a lovely poem by Anusaya Sengupta when she was in college, in Sri Ram College. And I would like to read that out to you. Too many women in too many countries speak the same language of silence. The laws are made for those women, not for those women who can shout like me. I don't go use that law. Always aggrieved. Only her husband had the cosmic right, so it was said, to speak and be heard. When a woman gives her love, as most women do, generously, she is accepted. When a woman shares her thoughts, as some women do, graciously, it is allowed. When a woman fights for power, as all women would like to, quietly or loudly, it is questioned. And yet, there must be freedom. We are here to speak. And yes, there must be power if we are to be heard. And when we have both the freedom and the power, let us not be misunderstood. We seek only to give words to those who cannot speak. Too many women in too many countries. This is a universal situation. So when Kofi Annan has had this to say on a very serious note, when women thrive, all of society benefits and succeeding generations are given a better start in life. And therefore today we have even yoga for premarital couples. We have counseling for pre-marriage couples. And what is our family court for? It believes in overcoming the problem. It values life, marriage, and children. It cares about the litigants' problems and respects their decision. And these family courts are made for reconciliation, not for only fighting. And when women come to fight, they are put down. I have done it. Please find out those judgments also. Thank you.
Thank you, ma'am. As usual, the insights are quite insightful. We would request Justice Dr. Shalini Joshi to give her insights and perspective on these aspects.
Thank you, Mr. Vikas.
Thing has gone.
After such a august gathering, panelists and their views, I mean, being the last speaker has its own advantages and disadvantages. Everything is spoken of, and what remains? It is like actually Sachin Tendulkar has batted so well, and then I myself at the last end coming to say something. So my friends, everything has been said, but yet I would come to basic things, that is gender awareness. What is, because our today's topic is gender awareness. So first we have to understand what is gender awareness, and for that, what is gender? Because unless we know the meaning of the term gender, we may not be able to understand the gender awareness as such. The basic thing is whether gender and sex are same. Answer has to be in the negative. Why I am posing this question is that our constitution talks of equality under Article 14, that is no discrimination on the ground of sex. So what does it mean? Non-discrimination on the ground of sex. So does it mean that only sex is to be considered, or what is it? I mean, how one can go about it? So whether there is a difference between the sex and gender, I would like to say that yes, there is a difference. So whether Constitution recognizes it because Constitution talks of sex, not talks of gender. There is not a single word talking of gender in the Constitution. And therefore, what does it mean? So I would like to say that, yes, Constitution talks of sex only, no discrimination on the ground of sex. But then in the National Legal Services Authority judgment, the Supreme Court has said that sex also includes gender. So when we talk of sex, we have to consider that it is gender discrimination again. So what does gender actually means? It is not biological. Sex is biological, gender is abiological. It means it has got nothing to do with biological or physical differences, but it has got everything to do with the social construct. So what gender means? The social construct terms, how the society looks at a man and a woman. What are their roles? What are their expectations? What are their beliefs? How a woman is supposed to behave, how a man is supposed to behave, which role a woman has to carry, which role a man has to do. What are the beliefs, how a woman has to conduct in a society and how a man has to conduct in a society. So these are all socially constructed notions or beliefs. And that is what the gender means. So gender keeps on changing, whereas sex will remain constant. It will not change, but gender will keep on changing from society to society, from ages to ages. I mean, what we contemplated for a woman to be at home only long back and not to be educated, not to be literate, not to work. Now we are changing that concept. We are accepting her outside the home also. We are accepting her as our colleague. We are accepting her to be an independent individual dignity. So this is a change in our perception. This is a change in our belief system. This is a change in our roles which we attribute to a woman. So this is what exactly the gender means. It has got nothing to do with biological differences. They may be there, they will always remain there, but despite that, how we look at and consider the woman as such, and therefore it has got something to do with social norms and power structures or power dynamics in the society. And our society as such being a patriarchal society so far, when we are talking of gender justice or gender awareness, we are talking of women's rights. Because so far, I mean, this is what the Constitution recognizes, and various judgments of Supreme Court, High Court also recognize that women are maybe on, receiving end. And that may be the reason when we talk of gender awareness, when we talk of gender justice, we talk in the terms of women's rights, the justice to women. And therefore, how the women look at, I mean, what is their perspective to look at the society? That is important. How they find the society, whether society understand their concerns, whether society is able to, I mean, respond to their requirements and needs as an individual person. This is all the gender means. And that is very important. And therefore, there are certain terms as regards, just as Dr. Ukey was saying, there are several terms in respect of gender. It may be a gender bias. It may be a gender sensitive. A person may be really gender blind. He will say that both man and woman who are appearing before me are same. I will not treat them differently. He may say that no, she is a woman, she belongs to weaker section of society, so I will be more considerate to her. Or he may say that no, I have to be sensitive because she is an independent individual and therefore I must respect her rights also. So there are several laws which respect, I mean, we can call as very gender sensitive, like Vishakha judgment or the POSH Act, Domestic Violence Act. So those laws can be called as gender sensitive. We have got the Constitution, Basic Law of the Land, which is very gender pro. I mean, it is going not only Article 14, but 15.3 especially, it gives a totally new dimension to gender equality, recognizing all the past discrimination against women and enabling the government to make special laws for women. So it is towards the end of substantive gender equality. So some laws, as I already said, or some perceptions, as I already said, maybe gender bias also, some interpretation of the laws, we will also notice that, yes, here the aspect of a woman as such is not considered at all. Her requirements, her perception are not considered. And therefore, we may call that they are gender bias. Some laws may be gender sensitive. looking at, concerns of women from their lenses, from their perspective, understanding, uh, putting ourselves in their position and understanding their feelings, their beliefs, their systems, that is more important. And therefore, when we say that in a case of murder, the complaint is to be lodged immediately. If delay, then we look at it with suspicion. But in case of rape, we become gender sensitive. We understand the condition of a rape victim in the society, how she will be immediately able to lodge the complaint with the police. She has to consult her parents. She has to consider the honor of the family. She has to consider the repercussions of lodging such complaint on her marital prospect or the marriage. And therefore, after considering all these, when she is lodging the complaint, we say that we take, and thereafter also we rely upon such complaint or the FIR, though there is a lot of delay, maybe of 2 days, as happened in Gurmeet Singh case. We are saying that we are taking a gender sensitive approach because we are considering all the social norms, the social beliefs, the social expectations from such a woman. And then we say that she may not lodge, no woman will lodge a false complaint. That is what sometimes we say. But now this concept is also changing, as we all know. Our judgments are there. We say that, which say that sometimes, yes, such false cases are being lodged, whether in rape law or whether in 498 AIPC. I am seeing repeatedly that question. So our way of looking at the things also keep on changing, and it has got nothing to do with her sex or biological differences. It has got everything to do with gender, because our concept, our understanding, our expectations from a woman or from a man are changing. And therefore gender is a way of looking at how social norms and power structures impact on the lives and opportunities available to different groups of women and men. And therefore, when we are talking of gender equality, which is, guaranteed under our constitution, under various international convention and treaties, we are not only talking of, making everything available to her equally, but we are also talking of the equal outcomes, equal opportunities. And thereafter only we can say that this is a substantive form of justice. So when we have to understand, our understanding of gender awareness is required to be increased when we have to consider the gender justice. And how to increase that understanding of gender awareness, because that is our today's topic. We will, in the course of this series, we will be considering other aspects of gender justice. But so far as increasing gender awareness is concerned, we have to follow certain, steps. Like one of the steps is talk to women and girls. It is said that women are absent in public discourse because what they know about their own case, own laws, own things, those views are never taken into consideration. And therefore, let their voices be heard in global and national decision making. And we all know that in parliament, whichever country, the representation of women is very, very comparatively very low, 10 to 20% in Asian countries. So let them speak, let them tell what are their concerns, and then only we will be able to increase the level of our gender awareness. Their voices should be heard, that is important. Let them have equal access to opportunities, especially in technology. Let them now, because of the COVID, everything goes online. Whether a girl or a daughter or a woman, a housewife is really having even laptop of her own, which she can use and work online, whether she is having all the mobile also, all these access, simple things, those access should be increased. We have to consider stopping child marriages and sexual harassment, because child marriage really comes as a barrier or hurdle in her progress. And so many child marriages take place, if you know the statistics. Akshay Tritiya, which is considered to be the auspicious moment or day, till now in various states, why to take the name of particular state, child marriages do take place, and it acts as a barrier to her progress, her education. It is also recognized that sexual harassment or harassment at workplace or violence which takes place whether at home or whether outside the home, that also acts as a barrier to gender creating, gender equality or gender justice. And therefore, when we are talking of increasing our gender awareness, we have to be we have to follow these steps. Security being entire concern of the parents is the security of the daughter, and therefore the child marriage or there may be some other practices, and therefore we have to make our public spaces more secure for women. We have to make our education, especially textbooks, gender sensitive. Gender equal, because there are several passages in the textbook and even in the legal field also. If you know, for so many days and years, Modi's laws on toxicology and forensic science used to have some passages like it is impossible to commit a rape on a single-handed on a woman, and that is many women lodge false complaints of rape, etc. Now those passages are removed because with the passage of time, we have realized that these are the concerns which are required to be addressed. We cannot have stereotype statement. We cannot have preconceived notions how a woman will behave. If she is wearing these, clothes, then she will be behaving, her complaint has to be false. So nothing like that. It is changing of our own concept. It is changing of our own belief system. Then we have to raise, when we are talking of gender awareness, we have to raise the aspirations of girls and their parents, because girls must know that they can, reach up to the sky, they can touch the sky. After, Kiran Bedi, so many girls and ladies wanted to be to enter into police force. After they come to know that, yes, Saldamini can be pilot, then they also wanted to be pilots. So, we have to keep some aspirations and dreams for women, girls and their parents. Secondly, we have to empower the mothers. Once the mother is educated, mother knows the value of education, mother knows the value of independence, mother knows that no, I will not tolerate such sexual abuse or domestic violence, then naturally she will ensure that her daughter also has the same value system. So it is important to empower mothers. We have to give proper value to women's work. They are doing all the household chores, but Chief Justice Mohit Shahji has said that their work is not valued in economic terms. Two-thirds of the world's work, global work is done by women, but then we are not valuing in monetary terms. Even as our concept of maintenance, I always say, is connected or dependent on need based. It is need based or dependency based. As she is dependent on the husband, maintenance has to be paid. It has something like charity. But if we consider her contribution for the home in monetary terms, in economic terms, then naturally this concept of gender awareness or gender justice will definitely come into picture. So unpaid work, we have to calculate. We do that exercise when a woman dies, a housewife dies, homemaker dies, we calculate whatever is amount of compensation due to her. So there we calculate her non-economic contribution. In maintenance and other concept alimony also, we have to value that household work. In COVID, in lockdown, the men have also realized, and this new normal will definitely lead to more equal society. Then we have to consider that let women be in the power center in decision making process, let them be the change agents, encourage women into non-traditional vocations, we have already said, and then work together with them. Once you have a wonderful colleague, maybe a woman or a man, it will really help you to understand the gender concerns. And in that aspect, we have to progress ahead and ahead, and we have to consider whether a woman, gender means really, if I want my daughter to be treated in a particular way, it necessarily follows that I should also treat my wife in a particular way. I should also, consider her individual dignity. And therefore, the upbringing of children, of making them aware of gender issues, making them aware that you have to respect a woman, you have to respect your sister, you have to respect your wife. And that is creating gender awareness, that is creating gender justice. A beautiful advertisement, sometimes gender also comes in communication and media. Like sometimes, this, there was a beautiful advertisement, and nowadays again some new advertisements are coming. They will help us to understand, like, this huggies pamper or these things. Husband was playing with a small infant, and then when the a child has the issue, he calls the wife, Megha, come here. Everyone in the family started calling, Megha, come here. And then he realized, even small daughter also started calling, Megha, come to clean the child. And then he realizes and says that when everyone in the family can play with the child, why only mother should clean the child when child has, done something? So I will do it. So now the gender roles, gender concepts are changing. We are having a beautiful advertisement of cooking oil, where both husband and wife, I mean Marathi actor Sachin Pilgaonkar and his wife Supriya, they are both doing in the kitchen. He is wearing the cap of chef and they are frying certain things. So, these our roles, woman is not only supposed to be confined to the household chores, household, man has nothing to do with it. We are now changing that concept, and that is what gender means. Now we are accepting the role of man and woman as equal partner in the homemaking, as equal partner in the development, as equal partner in the decision-making processes. And that really means the gender justice. I will give you one more example of beautiful advertisements when we daily see on the TV. But if we see it with open eyes, we realize how the gender perception comes in it. That in a very rich, wealthy family, the daughter-in-law is going outside for the work. And then the mother-in-law, when all of them were sitting on the dining table, mother-in-law says, why she has to go out for the work? We don't require it. And then at that time, it is the husband who says that, mother, it is not only for earning the money she goes out, but it is for her own individual dignity. She requires to go out. She is educated a lot. When we have brought the educated girl as a daughter-in-law, let her have her own choices. Let her decide. And this is where the gender comes. This is where, we are changing our belief system. We are changing our norms. We are changing our behavior expectations, roles. And that is what the gender awareness means. That is what the gender justice means. Ultimately, we have to take into consideration their perceptions of what they want. I mean, in that story which Justice Roshan Dalvi has said, the husband, I mean, the minister who has married with her, when she asked him what you want, and she very beautiful, and he says, it is for you to decide. I will not take your decisions. And then she felt so happy that she said, yes, right. You know that I have to take call. I have to take my own decisions. And this is exactly I want. So let her take the call, let her take the decision, and then she will be the best out of everything. And that is what gender, when we treat equally a man and woman, when outcomes are same, when opportunities are same, then it makes a difference to the society as such also, and progress of society. For economic development also, it is said that if women are, who are half of the humankind, I mean, when we use the terminology also, that is of utmost importance in gender awareness. Whether we really acknowledge, whether we say only mankind, whether we say chairman, whether we say this thing. So we are saying restricting that post of particular as a chairman to man only. We are restricting, when we talk of mankind, we are restricting it to men only. But when we talk of humankind, we are accepting that, yes, it also includes a woman because she is also a human. And that is what the Human Rights Charter or UN's Human Rights Charter also says, that women's rights are indefeasible, non-negotiable, and they cannot be bargained, surrendered in any way. They have to be respected like human rights. And therefore, when we talk of gender awareness or gender justice, whether it is a gender of women, now so far women were at receiving aid, but now we are realizing that even the third gender is also at receiving aid. They may not be having the as we know, the public places like public toilets or separate places for changing. So now we are realizing that it goes beyond that also, gender, that is what again the gender is, because that is what we are recognizing their needs, we are considering their requirements and accordingly molding the social beliefs, social systems, social requirements, and our norms, social norms are really sometimes very critical and accepting. Till now, we had no daughter doing any, funeral rites of the father. But now, after the death of Atal Bihari Vajpayee, our ex-prime minister, when his daughter did that, then we realized that this is something we can. So we have started accepting these things also, because now the social norms are changing. The woman is same, the man is same, but the society changes, the norms changes, and accordingly the gender concept changes, and therefore gender perception changes. And that is why the gender awareness is of importance, because we have to move forward. We have to go towards the progress and development, and to achieve that, all the humankind, entire humankind has to work together, and women constitute at least half of, or about half of the world's population of humankind, and therefore keeping them back, keeping them behind will not serve the purpose. We have to take them with it, and for that our gender sensitivities, our gender awareness, how we consider them is of importance. This is what I would like to say, and really thank you so much. Now let us have the question and answers. Over to you, Mr. Vikas.
Yes, yes, ma'am. Ma'am, invariably the questions are which have done, some are certain suggestions, but still what has come down is as to whether once there is a false case, what is the way and why the law is not projecting and progressing further under section 340 to proceed where we find, I will ask, this is a common question to all the four panelists. What is the way forward? How do we sensitize people that let's assume there is a false case? Because sometimes the damage which has been done is irreparable. So general perception which has come out from the chat box is, if there is some action strictly under section 340, then probably some things could be nipped at the bud. And as you said, it is all sensitization of the issue amongst the people. We also have Advocate Mrinalini Deshmukh, who has been participating in our session, and she was also one of the panelists. Since we had the advocates, we had the judges, and we had the Vice Chancellor, and a lawyer who is well established within the fields of the family law. We would like to have her perception on 340 because she has practical experiences. We are just unmuting Mrinalini Deshmukh, ma'am. Yeah, ma'am, you will have to unmute yourself. Yes, ma'am.
Yeah.
Mrinalini Deshmukh, ma'am.
Yeah. Good evening, all the eminent panelists on this platform. I mean, I've been just listening, absorbing, and sort of learning a lot from all these women and all the other judges, Mr. Mohit, Shah, and the Vice Chancellor. In my opinion, 340 is the most underused section in our proceedings which happen. And one of the reasons is, I believe that perjury is not taken as serious or as critical the offense which is there with the way it is taken in the other country. Now, I can tell you, as practicing in the family courts also. Now, there are cases where people have to make disclosures, and they do not make disclosures regarding the financial documents. They do not make disclosures about what their finances, etc. are. The courts will only then come to what is known as an adverse inference. But an adverse inference does not serve the purpose because the person who is not disclosed or who, besides disclosure, has made a patently false statement in the pleadings and in the argument on the instructions of things. There should be some kind of strict action about it. And in my limited experience that I worked at, and I'm sure this is more in the other cases also, we have seen that the courts are not taking such firm action against the litigant or the person who is before them who is making false statements on oath. So I think it's one of the things that and I think more than me, I think it will be all the judges who've been dealing with these matters who will be in a position to tell us exactly as to why is there a hesitation and why does it not serve as a deterrent so that subsequently there will be less such cases which are there. So I think that's the way I would like to put it as far as Section 340 is concerned.
Ma'am, since you have been practicing, the subtle difference between, we will have also from the panelists, the subtle difference where I'll be exercising the powers under 182 and 340. What is your take on that? And how do we sensitize the society at large for perjury and filing of false cases? We are putting this question open to all the panelists, and since Ma'am Deshmukh has also joined, we consider it as a part of the panel itself. So we'll be posting this question in common. What is the way forward and what could be the suggestions for that? We can ask Justice Shah to put the words forward.
Justice Roshan, Dalvi and Justice Panchalkar Joshi have worked as trial judges. Therefore, they would be better able to answer this question. But I want to point out that it is one thing to say that I don't believe the wife, and it is another thing to say that I disbelieve the wife. I mean, a party, whether wife or husband. So the powers under Section 340 cannot be invoked when you don't believe a witness. It is when you disbelieve the witness. That is my perception. So for disbelieving, you have to have greater material or greater, burden on the other side to say that what the other person is stating is false. Therefore, that would require further more inquiry. So judges who are already overburdened, they would rather, they may not then go to that length, because to say that a person is making a false statement, it requires a greater material or greater work to be done by the court. What do you say, Justice Dalvi, on this for exercising the powers under Section 340?
Well, if there is any litigant, it need not be a woman or a man or whoever it is. If there is perjury, action can be taken. For taking that action, not only the judge, but also the clients must move to that end. Now, generally, when this domestic violence complaints comes about, then there is a talk of settlement, and they say that you need your life now. Why are you wasting your time in court, etc., etc.? And we try to bring an end to it. So there is some kind of reconciliation. Reconciliation does not mean only going back home together. Reconciliation is also by an amicable divorce or separation. Now, if the parties want to do that and not waste their lives over it, there is no way a judge can take it forward otherwise. But if a party goes through the domestic violence complaint completely and proves the case to the hilt, then only it can be shown that one party has perjured himself or herself. And of course, if there is perjury, no question about it. If there are parties who want to go through whole hog because there is a false case put up either by a woman or by a man, then courts will take it up. Only thing is, it will take 20, 23 years in our system in a city like Bombay, because we are bursting at our seams with cases. And therefore, we have got this thing of mediation. We have got this culture of reconciliation under Section 9 of the Marriage Act. And this goes by the board. That you forget about this. A happy marriage is a union of two forgivers, as they say. But even if it was not a happy marriage, be a forgiver. Forget about it so you can spend your life better afterwards. That is how these cases are not coming up for perjury. Because unless the entire criminal trial is over, no judge will be able to decide that somebody has perjured himself or herself. And that doesn't come about. That stage doesn't come about. If that stage comes about, we would take it up. And that would mean so many cases, not only in women's cases or in marriage cases. In ever so many cases, the parties who fully perjure in our system.
Yes, Dr. Panchalkar Joshi.
Yes, I fully support both of you. I would like to add that the standard of proving the perjury is very high, because it is required to be proved strictly. It is being a penal offense as such. Secondly, merely because a witness has stated something false doesn't mean that he has perjured himself. because there are several considerations. We know in the, cases of sexual violence, or even sometimes other cases also, sometimes the advice, sometimes there are several constraints. So when a litigant comes to the court, he should be given access to court. Access to justice means not only having a structural court, access to structural court as such, structure as such, but access to justice means he should be given all the opportunities to prove his case. It may not be to be proved by false evidence, but whether he really believes it to be false or not, whether he, according to him, that evidence is false or not, and despite that he has deliberately, purposely relied upon it to achieve another end. So, there are several considerations, and as they say, the court's shoulder, judge shoulders must be broad enough to, consider these aspects and thereafter to issue the notice of perjury. If we start using that power, very often, then it will lose their sting also, they will lose their deterrent effect also. And secondly, the entire new litigation will be, piled up in the court. And therefore, judges feel that we have to consider why he has done it. I mean, it is nothing to do with woman, man, or anyone else, but we have several considerations in our mind when we want to invoke these powers, and that is at the end. And another sort of litigation, why to involve the parties to it? Ultimately, what justice? I mean, everything has to be considered, and therefore sometimes the courts are little bit lenient, I think. That is what I feel. Thank you.
Another way, ma'am, of late you would have seen the trend is that let's assume we may not even touch perjury, but there are two flip sides according to me. I will ask ma'am Deshmukh also on this flip. One is that if we punish 1, 2, 3 persons, it acts as a deterrent for the other people. Because if we think that the courts are already overburdened on this aspect, and we do not proceed despite the fact there is an overwhelming evidence, then it slightly becomes, the image goes slightly in a different way, that despite the fact there is an evidence to the effect that there was misleading, because in maintenance cases, there are certain aspects once wife is living separately. There could be cases wherein she's working, but still she claims that she's totally unemployed, she's not earning anything. And then once the evidence comes, that point, and if there is a notice even issued, like we had once one of the webinars on false claims by Justice J.R. Mehta. And he said that even on the issuance of the notice itself for filing of the false claim, in large number of cases, the parties had actually withdrawn those cases when they realized that they are on the wrong side of the law, number one. So once that situation arises, I will ask Ma'am Nalini, what is her take on that? That because it sometimes happens. I have also seen, like we have gone for a maintenance saying that the wife was already well placed and she's not doing this thing, and we had put on record the evidence to the effect nowadays, because large number of things, EPF, etc., is paid, and there are documentary evidence. And that particular situation, invariably, the parties have, I will not say in a right sense that they've seen the differences, but at least they have praised out the differences. They have arrived at a settlement. Maybe like just we had one of the webinars with Justice Shah when we had talk of ADRs, or what we Justice Roshan Dalvi had a talk in Kerala Bar on the ADR part. That actually, once there is a trigger on that aspect, then it does actually help to settle the matters. Number one, in that particular case. And number two, the other parties who are, the word fence sitter may not be the right word, but at least the person who wants to do that, this news actually spread. They say that good news and bad news travel. Question is only of the speed, but news definitely travels. That the courts Deshmukh, and then we'll ask Justice Roshan Dalvi what is her call on that.
So Vikas, in my view and in my experience that I have seen, and I do represent in the family court a large section of men also, I mean husbands also, what we see. And this is not any such statement that I'm making, which is that particular gender, that whether there are women who make false statements on oath or there's men who make. But what happens is that I have seen, and probably it's at an interim stage or probably even at the final stage, what the courts go into is they want to look and pay more attention on the main issues that are there before them, rather than go to these ancillary, if I may call that, such issues which are there. As a result of which is that such a strong section and such an effective section which is available is less utilized is what I feel. And that is why the effect of it being a deterrent is not being served. That is point number one. I just take a minute more. And secondly, and more importantly, as Justice Dalvi rightly stated, that after, as judges, as lawyers, as all of us, we try and settle the matter. After we settle the matter, the first statement is all allegations made against each other are withdrawn. That is normally the first line that we write in the consent terms when a contested petition is converted into a consent petition. Now, once you say this, then obviously they are taken to be allegations and they are withdrawn. So it does not give the message loud and clear that any false statements which are made will be treated otherwise. But I do completely understand where the courts are coming from, that they need a solution to the problem and not add to the number of provisions of law or other things which are there. My only concern is that my experience, and I may be completely wrong, I may be a minority, I may not be the only person, but the courts are not seriously considering this as one of the effective measures to be used to be able to rule out anybody making false statements. Because otherwise, that people can get away with murder also. This is what I feel. And this is not only about the judges, it is also about lawyers like me, that we have to do the fact check. We have to do our own due diligence before we make those statements. Ultimately, the statements are made on behalf of the litigants only. But despite that, I would suggest that if a strict action is taken by the court, even at times suo moto, I mean, it need not necessarily be that a client has to follow it up. If the court is satisfied once the documents come on record, even the courts can suo moto take such things which are there, only with a view to serve as a deterrent. And we have a judiciary where people do literally and really come with clean hands and not with unclean hands to mislead the court. That's what I would say. Thank you.
I think in countries like Switzerland, the courts are given, the same court has the powers of the civil court as well as the criminal court. So if there is such a system in our country also, then in the same case, the judge heading the family court or the civil court can exercise the powers of the criminal court, and then the deterrent power can be exercised more effectively. That is one way out, one way forward.
Yes, I agree, sir. I agree with you.
Because at present, otherwise, civil court will only say that complaint should be lodged against under section 340. So then the case will go to the criminal court.
Correct.
Same judge will not be able to then try that case.
So that time, Justice Midha said that the bars he had been exercising on the filing of the false case, he used to issue notices, and thereafter he said large number of cases, not only those cases were withdrawn because they said they realized that they're on the wrong side, number one. And it also acted as a deterrent to the other persons, because what in the ordinary parlance could be that if we don't take action against the persons, or I'm saying any party who's filing a false affidavit, let's restrict it to the issue of gender, this thing. But we have been finding the cases where the honorable courts have been imposing cost of 1 lakh, 10 lakhs, just to deter that person. It actually not only deters him, but it also deters to the other person, because the lawyer who would draft it would also advise him that on your asking, I can put it. But on the asking of yours, filing of the false affidavit, you can be on the wrong side of the law, and you could actually hit yourself on the wrong side. We also, amongst his, Mr. Chirag will say that there's the difficulty with because of heavy rains with Professor Dilip Ukey, where he's putting up. And he has also written articles and books on criminal law. And he's also a professor in the MNLU. So we will also take his insights, because he has also been going on a lot of webinars, moderating, etc. So what is his take? Because he has done some practice and also was teaching and writing books. What is his take on this, Mr. Chirag? Because we say that we can only get enlightened once we are in and around the Chirag.
Thank you, Vikas. Thank you for having us and for asking this question. I won't get into practice area because we have 3 honorable judges. And as I see in the list of participants, our honorable registrar, who also happens to be a sitting judge, is also there. So I won't comment on the practice area, but as far as deterrence is concerned, in criminal law in India as well as across the jurisdictions, there is no proof or there is no objective data that deterrence theory works. However, there is sufficient evidence that conciliation, idea to mutually agree, mutually settle the dispute do work. So too much of reliance that if we try to deter an individual, if we try to criminalize the conduct, that too in a family affair, though there may be a perjury, there may be a bad taste in the relationship, things might have gone haywire, but at the end of the day, people have to move on. And this is what our respective justices has also reflected upon. So parties may have a grievance, but the litigation or a criminal law proceeding at the end of the day just gives you a baggage at the end of the day. And as Justice Dalvi rightly pointed out, another 20-23 years, definitely judges can take this stance conducting the trial court case. But I'm not sure, first, if it would be deterrent. Second, it would be in the best interest of that individual also. Third, as Justice Shah rightly pointed out, if still a person wants to pursue a case, he can always pursue a case by, or she can pursue a case by going to a criminal court. Nothing stops them. But the burden of proof, as Justice Shah rightly pointed out, is going to be very, very higher as compared to family court. Family court, we decide the case by mere balance of probabilities. In the criminal case, the burden has to be proved whether there was a perjury or not by the standard of beyond reasonable doubt. So how are we going to balance these considerations is a practical consideration, all of which we have to consider. Thank you.
Mr. Chirag, rightly in terms of the name itself, maybe you gave a short talk, but you gave that illuminating mindset to the session. As we were asking Justice Roshan Dalvi, what is her take on that? Over to you, ma'am. What is your take where these false cases are there, how to act as a deterrent, etc.?
If there is going to be an amendment of the law relating to perjury, allowing a magistrate in a 498A matter or in a domestic violence matter, when it comes to the conclusion that a particular statement was perjurial, to take notice and to immediately pass some orders, then there would be right. But it requires a new law. Today's laws are such that you will go wheels within wheels. If suppose a party wants to take it up, the party can always call upon the magistrate to issue the complaint and start de novo. That is what has to be done today for perjury.
What all suggestions, except for perjury, what all suggestions we will post it to all the 5 panelists to the effect, I'm taking Ma'am Deshmukh also as one of the panelists only, that what is the take while winding up for today's session on the uncoding of the gender justice, because in that endeavor we'd also like what suggestions, because they say, because what is an idea, what the thought becomes an idea becomes an action, and action actually becomes the thought process and ultimately the result. So if we have to wind up, what is your quick take on this? Because we have seen the lot of messages being done there. So I personally felt after all these questions, we have not taken the questions. But what is your take, whether the heavy cost should be there, whether we should go with perjury, or the courts itself have to be empowered in the sense that once you come to know in black and white to the effect that, yes, one of the side has done wrong deliberately, knowing that the things were not right, because we will also find a lot of cases where dowry FIR is registered, court is set into the motion because of the allegations. You will also find on the face of it that party is not to that financial status, yet there are allegations maybe ultimately compromised. But the chat shows that we shouldn't end ultimately into compromise. I'm just reminded, like when what we say in the mediation settlement, that there is a dispute between a party of the oranges or the marmalade. One gets the juice, one gets the peel, so that he can make the pickle out of it. But question is how to proceed further so that actually we can arrive to a situation where the parties do not trigger the set into the motion of the cases by the initiation at the false affidavits or false statement at the outset. We just take one suggestions from all the 5 panelists. We will start from Chirag itself, then Justice Shalini, then Justice Roshan, then Ma'am Deshmukh, and ultimately with Justice Shah. Over to you, Chirag.
Thank you, Vikas. So my suggestion is very simple. First of all, using the word perjury is very hard. Perjury has a very specific connotation, and reading the chat box, I understand most of the people are talking about false prosecution. So we have a provision in CRPC for false prosecution or malicious prosecution. There are provision in torts law also to deal with malicious prosecution. Question of perjury comes where a false evidence has been created. And I think whenever you are bringing false evidence, lawyer has to take equal responsibility in that case, because without the support of lawyer, either party cannot present the full evidence, false evidence. So I think in that way, a balance need to be drawn. First, we need to be conceptually clear whether we are talking about malicious prosecution or we are talking about perjury. Perjury, in my experience in family matters, does not happen that way. People really don't create false evidence, they exaggerate the allegations. So a person might have hit a slap, the allegation might be that no, I have been beaten tooth and nail. So whether you would call a false allegation, whether you would call it perjury, I'm not sure about it. Actually, it is an exaggeration of, and even in regular criminal cases, we know that there are different kinds of witnesses, and we have a class of witness where we say that if a witness is of this nature, that to people from village, people coming from village background, there are plenty of judgments from the Supreme Court where we are saying that these are rustic witnesses and these people tend to exaggerate in their testimony. So we don't launch any prosecution in those cases. We just reduce the relevancy and the relevancy of, not relevancy, we reduce the weight of their testimony. So that's one part of it. Second part is false allegation, false complaint, that's malicious prosecution. Provision is in CRPC as well as torts law. Third thing is perjury, which is an extreme kind of offense. And if the court finds it, court is very well within its power to take a suo motu action also against the lawyer as well as party. And if the court does not take, party has all the rights. But should that be done depends upon whether party wants a life without a baggage, emotional baggage, or a relationship baggage, or it wants a life where it wants to drag the case for year after year. That's my opinion. Thank you.
Meanwhile, Nalini Deshmukh ma'am has posted a message that she had to go for a webinar. We'll ask Justice Shalini because there are submissions that we can also proceed under Section 182. And be that as it may, what other suggestions we can have to the effect that how we can nip such a problem where there are false cases under the relations of gender law.
Thank you. I fully endorse what Mr. Chirag has said, that we have to distinguish between perjury and malicious prosecution. And as I said, perjury has to be absolutely thoroughly, without any doubt, it should be a false evidence. And it is very difficult to say the false evidence as such. But if the court comes across such case and court is moved by the advocate or other or the party, then the power is there. Court, in deserving cases, the court definitely should use, and courts are using, but it is not a regular weapon to be used in each and, I mean, you know, it is not to be used like ordinary weapon. It is a weapon which is required to be used in deserving case only. Thank you.
Ma'am, what is your take? This is Roshan Dalvi.
Yeah, almost what I already said. We must come to the end of the case. Then a magistrate or a judge would decide whether this case was a false case, a perjurial statement was made, etc. Unless we come to that stage, you can't just issue a perjury notice because the other side says the case is false. You understand? The burden to prove a case is tremendous in all criminal cases. And once that is done, and if that man is acquitted after the entire evidence is over, on the ground and with the judgment that this case was false, that is the case which would then go into this channel. But how many cases are there which come to that stage? How many people can show that this evidence is really false? A woman makes a statement, she comes to court, she may make a right or a wrong statement, she may make a false or a truthful statement. But you have to come to the end, you can't just from the beginning say that this is a perjurial statement.
what is the take of Justice?
In the one stage, can you begin the next stage?
What is the take of Justice Shah, because he has the experience not only on the webinars and seminars what he's taking, but also as a lawyer of immense practice, then thereafter in 3 high courts. What is his take? What has been his take as to whether how many cases he felt that they are false? And what was his feedback? Because while being an inspecting judge, you also get the pulse of that. And what is his take? What is the way forward? Because sometimes till waiting till the end, what is the way that we can actually put the message to the society that yes, these false cases are actually not built up? Because sometimes, as we all discussed, some relationships are on the verge where it can actually connect back. As they say in Japan, that once there are pots cracked, then they use gold so that the pot becomes much better than what it was originally. So what is the way forward where some relationship has got a bitterness, but the false cases can actually only catalyze the differences to a worse end? So what is the way forward where the relationships can be improved also, and people also have more faith that yes, if you're filing a false affidavit or false this thing, though we had that judgment of Honorable Mr. Justice Kuldeep Singh where it says fraud vitiates everything and false owners, false omnibus. How do we take things forward for that?
As I suggested earlier, all the courts should be conferred with the power of the court under section 340. So then once the courts have that power, the witnesses as well as the parties, will be slow in making false statements. But at the same time, the judges will also be trained properly to exercise these powers, because as Professor Chirag earlier said, it's when there is a exaggeration, that does not mean falsehood. So the court also will be very circumspect in distinguishing between cases where there is falsehood and there is exaggeration. Where there is outright falsehood, the court should then exercise those powers. So my view is that the court should be given such powers. So the same court can exercise that power at the time of giving judgment itself and then taking up the matter under section 340 of this year.
Thank you, sir, and all the participants. The first part of our series, it shows the number of participants which were here as well as on the Facebook, that it has been well received, because as they say that any idea has to be first conceived and thereafter it actually translates into the realities. And what we discuss on any platform, not I'm saying on the panel of Beyond Law CLC in collaboration with the MNLU, but any suggestions, any takes which are there, they ultimately sometimes actually trigger off in the right sense and culminates into a right thought process in that. We are all grateful to all the participants and who have participated not only on this platform but also on the live Facebook. Before I will formally conclude, I will just ask Chirag, since I've been told the Vice Chancellor couldn't connect us, to say a few words and how we move forward in these series in being a knowledge partner of MNLU, because definitely one of the webinars will come on this gender law itself in the partnership. And we are also quite sacrosanct that since it has triggered a right thought process, we will also have more webinars in collaboration with the MLNU. Over to you, Chirag, we are unmuting you.
Thank you so much, Vikas, and thanks to former Chief Justice, Justice Mohit Shah. In fact, Justice Mohit Shah was the first person who visited our university when way back it was set up in 2015. And Justice Dalvi is also one of the regular faculty members at the university. I still remember the contract classes which she took way back in 2015 at the TISS campus. We had the classes, and definitely Justice Shalini Pansalkar ma'am, I've heard a lot about you from our Vice Chancellor and Registrar, from all three of you. I've met Justice Shah and Justice Dalvi, but didn't had the privilege. So on behalf of university, I'm thankful to all of you. Vice Chancellor sir really couldn't continue the program because of the poor internet connection. He tried multiple times and he has extended his apology in that regard. So thank you, Vikas, and thank you, everybody.
on behalf of the Vice Chancellor, I can only say that since it's a series, often we say that koi raat itni sangein nahi jis raat ki subah rangeen na ho. So we are quite sacrosanct that the next webinar we will have more insights from the Vice Chancellor. We will looking forward. Thank you everyone, and the participants who felt that it was a one-sided chat box. We are also happy to that, because sometimes the what they say chingari left by them gives us the perspective that we should think differently, and we started differently. We would always ask them to participate, but yes, don't just keep on barraging the messages just like AK-47. The messages time and again repeated on the same perspective will not say, as they say that, I'm not saying that they are false, as they say, a wrong is a wrong even if 100 people say it's right, and a right is a right even if one person says it's right. So once you post a message on one particular aspect, we would be happy, and the point would be well noted. You can appreciate that the panelists are of extreme knowledge. The message once posted on the chat box would be suffice to convey what you actually want to convey. And I can assure on the part of the panelists, those who will join us, that yes, the point which you post will be received and will be conveyed. It could be thought pondered, and ultimately we can be seen in the right way. So everyone stay safe, stay blessed. And tomorrow in our series of the webinars, tomorrow we have amongst us, I'm just the exact topic. Tomorrow we will have 10 misconceptions about Articles 226 and 227 of Constitution of India, whether they are actually a misconception or they are the realities, the analysis and discussions by Honorable Mr. Justice K.S. Radhakrishnan, former Judge of the Supreme Court of India, and Mr. Esteemed Panelist, Senior Advocate and a former President of Gujarat Bar Association. They both would be giving their insights that what misconceptions according to them are within the powers under Article 226. Whether they are misconceptions or realities, we would also see how to move things. Thank you. And those who feel that it's a one-sided affair, we are too happy with that. As we say in the scales of balance before in the judicial system, the scales balance tilts towards one side and try to put it back. We assure you that from the next time onwards, according to us, it should not be a one-sided, though we try to make it not to be a one-sided. But as they say, there are always three sides of a story: his, their, and what public see. Thank you, everyone. Stay safe, stay blessed, stay connected.
Okay. Thank you.
Everyone. Thank you.